In the case of Sullivan versus Ferguson, the so-called large capacity magazine ban case out of the District of Washington, that's Washington State, the federal judge out there has asked for a briefing by the parties whether or not he should appoint a historical expert to teach him how to apply the Second Amendment's right to keep and bear arms. Sound absurd? It sounds like it might be absurd. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms and help us get to 100,000 subscribers. We think it'll make a big difference with the social media algorithm. All right, today, in the state of Washington, federal district court out there, Judge David Estudillo, a recent appointment to the federal bench by Joe Biden, is presiding over a case involving a challenge to the so-called large capacity magazine ban in the state of Washington. This challenge is brought under the Second Amendment. Now, we're probably going to talk a lot about this case down the road, but I want to talk about one thing that just occurred, that this judge just entered an order asking the parties what they thought about the idea of this judge, a federal district court judge who swore an oath to uphold the Constitution, by the way, including the Second Amendment, by the way, whether or not he should appoint a historian or some sort of history expert to teach him how to apply and understand the meaning and scope of the Second Amendment. That's right. You see, Judge Estudillo entered this order, which I'll link to down below, saying that under NYSPRA versus Bruen, once a modern-day gun control law implicates the text of the Second Amendment, which a ban on so-called large-capacity magazines would, because magazines are, among other things, an arm, because they are an essential component to a firearm, among others. There's many reasons why they're arms, but nevertheless, they're clearly arms. And because that impacts the right to keep and bear arms, it is a modern-day gun control law, which means that the burden is on the government to justify under the Constitution that this is some sort of a long-standing traditional gun control firearms regulation, which is not possible for a reason I'll get to in just a second. So anyway, the judge has come out and said to the parties, tell me why I should not appoint a federal court-ordered historian to teach me about the meaning of the Second Amendment, because I'm not a historian. He then, ironically, or amusingly really, he cites to Judge Reeves, you know, that judge we talked about a month ago down in Mississippi, that said because he's not a historian, he's not in a position to apply the Second Amendment as articulated by NYSPRA versus Bruen, because he needs historical teachings. He needs lessons in history. That's obviously completely stupid, because what is the role of a judge, right? What is the purpose of a judge? Well, a judge takes older documents in various forms and applies to the modern day controversies. Let's just take a couple examples. Hello? A contract case. You get a dispute into a contract. Well, contract may have been entered 5 years ago, 10 years ago. Well, now the contract's in dispute. So a court has to interpret the contract from 5 or 10 years ago and apply it today. That's an older legal document. You don't need an expert to do that. You got to read the contract. You got to apply basic legal principles, and that's what judges do every day. Statutes. We have federal statutes from the 19th century that are still fully enforceable and applied every day in American courts. You don't need an expert in 19th century law to teach a federal judge how to apply 19th century or 20th century, for that matter, federal statutes or state statutes. That's what judges do. They go back in time, they read old documents, whether it be a contract or a statute or a constitution, and apply it. Likewise, the United States Constitution is over 200 years old. We still use it every day. The Constitution creates the presidency. The Constitution creates the Senate. The Constitution creates the House of Representatives. The Constitution creates the Supreme Court and the federal courts, and so on and so on and so on. It's been the case for over 200 years. You don't need anybody coming here and teach a federal judge whose job it is to apply the law what the Constitution means. That's what the judges are supposed to figure out. They have the duty to interpret and apply the law. So the fact this judge feels the need, now he hasn't done it yet, so I don't want to beat him up here because he hasn't decided yet. He only asked the parties what they think about the question, which is okay. You can ask a lot of questions. But the fact that the judge is asking, do I need to appoint a historical expert? Obviously, the answer is undeniably, no, you don't. It's your job to take what the parties give you, as NYSPRA versus Bruen teaches. The Supreme Court says you take what the parties give you in terms of historical analogs or evidence or arguments, and you consider them, you decide it like any other case. So keep in mind, but before we get specifically to why historians are not needed as historical experts in these cases, I want to say one quick thing. Judge Estudillo here is already off on the wrong path legally, and hopefully someone educates him on this. Here's the thing. If you're dealing with a gun ban case, if you're dealing with a magazine ban case, what you're talking about is an arms ban case, right? The right of the people to keep and bear arms. So if you ban arms, I mean, if the state bans arms, any form of arms, it could be a magazine, it could be a semi-automatic rifle, it could be a handgun, it could be a stun gun, as we saw in Caetano in 2016. These are gun ban or arms ban cases where you're banned from possessing these. Here's the good news, Judge. Here's the good news, Judge, in America. Guess what? You don't need to worry about historical analogs if you're dealing with an arms ban case. Totally irrelevant. Why is that? You see, the United States Supreme Court, as the Supreme Court, above all the quote-unquote inferior courts, which is what Article 3 of the U.S. Constitution calls the lower courts, the courts of appeals and the district courts. They are the inferior courts, not my language, the constitutional language, Article 3, U.S. Constitution. The Supreme Court tells the lower courts what to do. And in Heller, the Supreme Court set forth the standard, having reviewed all the relevant history and the text of the Second Amendment. They already figured it out, that if you're dealing with a gun ban or an arms ban case, like we saw in Heller, which was a handgun ban case in D.C., then the only question is the handgun or is the arm commonly used by Americans for lawful purposes? Again, is that arm that's been banned used by Americans for commonly used by Americans for lawful purposes? If the answer is yes, it's game over. You cannot ban it in America. You cannot. That's what Heller taught, right? You cannot ban handguns in America because they're commonly used by Americans for lawful purposes. That's what Heller taught. You don't get another crack you don't get another crack at this, right? Likewise, in Caetano in 2016, the U.S. Supreme Court did the same analysis again. If an arm, in that case a stun gun, which is not a firearm, if a stun gun was commonly used by Americans for lawful purposes, it cannot be banned. And guess what? In Caetano, there was only 200,000 stun guns in American life at the time. We know that for a fact there are, tens of millions of AR-15 style firearms that are semi-automatic rifles in American life, and we know there's well over 100 million magazines that hold more than 10 rounds in American life as well. We know this from, among other things, the Georgetown University professor's study, Bill English's study, came up by, I forget the number, but I want to say his conclusion said that somewhere in the order of magnitude of 500 million, that's billion with a B, 500 million magazines with more than 10 rounds in America, based on his work at Georgetown University. So anyway, no matter what number we're talking about when it comes to magazines that hold more than 10 rounds or semi-automatic rifles, like AR-15s and AK-47 style semi-automatic rifles, we know there are more than the 200,000 stun guns that were protected arms under Caetano. Okay, again, you don't need historical analogs because the Supreme Court has already articulated the standard of review. They've already articulated the legal standard in assessing a gun ban or an arm ban case, which would include a large capacity magazine ban case. It's whether or not they're commonly used by Americans for lawful purposes, because there's undeniably true that magazines and AR-15 style firearms are lawfully owned, commonly owned, and lawfully owned by Americans for lawful purposes. Guess what? Game over. We win. You don't need historical analogs. You don't need historians. You don't need any of that. The Supreme Court already did that work for you. You just have to apply it as a lower court. But let's go beyond that. Let us assume, for the sake of argument, that these judges decide to go beyond the common use test, which they should not. No need. Waste of time. But if they do, and they go to look at historical analogs, they certainly don't need historians or anything of the kind to figure out what the meaning of the Second Amendment is. How do we know this? Well, again, let's look at the United States Supreme Court. I repeat, the Supreme Court, which is to be contrasted with the inferior lower courts, not my language, Article 3, U.S. Constitution, that's that language. Guess what? Now, the United States Supreme Court in Heller wrote literally dozens upon dozens upon dozens upon dozens of pages discussing the history, the meaning, the scope of the Second Amendment's right to keep and bear arms, all on history. Guess what? All without any historical experts, all without any testimony, all without a trial, all without a testifying experts talking about history. Why? We know this for a fact. Why do we know this? Because in the Heller case, Dick Heller and the plaintiff sued D.C., and D.C. filed a motion to dismiss that was granted. It went all the way up to the Supreme Court, and we won the Heller case. There was no trial. There was no testimony. There was no nothing, because it never got to that stage. Nevertheless, the Supreme Court was more than capable, without the benefit of historians and experts, to write literally 60 or 70 pages of historical documents and discussions involving the meaning and the scope of the Second Amendment. Likewise, if you look at NYSPRA versus Bruen, another case decided on the pleadings, meaning there was a lawsuit brought by NYSPRA and the plaintiffs in New York State. New York State filed a motion to dismiss. It was granted. The case was dismissed. And then the plaintiffs took an appeal all the way up to the Supreme Court. And in NYSPRA versus Bruen, literally 50 pages or so of historical discussion of the right to bear arms and the right to carry arms in American life was discussed, all about history. Again, in the Bruen case, no trial, no testimony, no experts, no court-appointed anything. So in short, if the United States Supreme Court can decide the meaning of the Second Amendment in major cases like Heller and Bruen, all without trials, testimony, experts, or any of the like, and interpret the Second Amendment and apply it in controversies and cases, there is no doubt that lower courts, such as those sitting in the United States District Court for the Western District of Washington, can do the same without court-ordered or other types of experts, including historians. And let's go beyond the Supreme Court's decisions in Heller and Bruen, and also in Caetano. Remember, in Caetano, the only testimony, there was no historical evidence in there either. The only thing in Caetano was there was a very short trial that demonstrated that Jamie Caetano had a stun gun and that it was a crime under the law of Massachusetts at the time. There was no testimony or historical discussion at the trial court or any historical evidence about the meaning of stun guns, the history of stun guns, the history of the Second Amendment. None of that occurred, and yet the U.S. Supreme Court in Caetano in 2016 was able to say that stun guns are protected arms as commonly used by Americans for lawful purposes, and thus they're protected arms. Again, no need for historical analogs or any of that stuff in a gun ban, arms ban case. But let's go beyond and talk about historical analogs anyway. Let's assume that historical analogs come up. Well, let's look at the record. NYSPRA versus Bruen was decided in June of 2022. We've had, going on 7 months worth of various Second Amendment cases. In the last 7 months, as I can tell from my review of the record, and maybe I missed a case, although it's unlikely, we've had countless decisions, many of which are in our favor in terms of the Second Amendment, some of which went against us in terms of the Second Amendment. And guess what? I'm not aware of any of those cases that involve testimony from historians or expert historians to teach judges how to interpret the Second Amendment. In fact, we've had several judges. I think Judge Estudillo in New York, I think Judge Benitez has indicated from the transcript that I read that they don't think they need to have a historian come in and teach them how to interpret the Bill of Rights, how to interpret the Second Amendment, how to interpret the Constitution. It's their job to interpret the law. That's what federal judges do. They take old documents, contracts, old statutes, the Constitution, and apply it to modern day controversies. It's what judges do. You don't need to bring in and outsource your job to some third party. That is your job to make the final decision of what the law is and whether that law is the contract, whether the law is the statute, whether the law is the Constitution, whether that law is the Second Amendment. That's your job as a federal judge. You don't outsource it. Okay, and we know that in the last 6 months there have been countless decisions, mostly for the Second Amendment, some against the Second Amendment, but they've applied the Second Amendment, and I don't think any of them have used expert testimony in the forms of historian yet, and there's good reason for it because it's totally unnecessary. Keep in mind that we talked about that case down in Mississippi in the United States District Court there in front of Judge Reeves, who raised these criticisms of Bruen because he wasn't a historian. It was obviously an absurd argument. What's interesting in that case is the Joe Biden run, Merrick Garland run Department of Justice actually submitted a brief there saying that they don't think that you need historical experts either. So here you have the Biden administration saying that they don't think you need historical experts talking about the meaning of the Second Amendment either. So if you can't even get the Biden administration run by Merrick Garland to take a position that says you need all this extra burdens to, apply the Second Amendment, that's telling you quite a bit, because I would think if anybody would argue that we need infinite amount of money spent on expert witnesses, it would be the Biden administration, and they're not saying that at all. In fact, in the case before Judge Reeves down there in Mississippi, which we talked about before, the Department of Justice specifically says they don't think we need any of this stuff because the Constitution is applied every day, and you don't need experts. You just need to let the parties argue about what the Constitution means as applied to their case, which happens every day in American life, and let the judges make the decision. If there's a disagreement, you can take an appeal. Okay, one final point I want to make about historians. Step back for a second. What exactly do historians do? We know what plumbers do. They fix your plumbing. We know what air conditioning repairmen do. They fix your air conditioners. We know what chefs do. They make food. What do historians do? Well, historians, as I see it, really do two things. I repeat, historians do two things. One is they go find history. They go into attics. They find old diaries. They find old documents. They interview people. They do all sorts of things to uncover history, to try to basically uncover it, right? Those are primary sources. They try to find an original letter, the original Constitution, the original Declaration of Independence, the original letter between Madison and Jefferson, whatever it is. They go out and they try to find original primary sources, number one. And number two is they present that information in the form of a book, in the form of an article. Maybe they do a YouTube channel. Maybe they give a lecture, whatever it is. Again, you have historians who go out and find the history, figure out the history, and then they present the history. So if you think about it in terms of a fight over the meaning of the Second Amendment, where the government bears the burden to come forth with, 1791-based historical analogues to justify modern-day gun control laws, really the only role historians have is to have flagged these historical primary sources, these laws, that the government or whoever's trying to justify the existence of these modern-day gun control laws, they come forth and they say, hey, we found these statutes and we want to talk about these statutes. Well, guess what? Judges, again, as we know, it's up to the judges to read those statutes and take a look at the history associated with the statutes like they do every day. This is legal history, right? It's not random history. It's legal history associated with the American law, which is what judges are all about, American law, and then have that help you interpret what it means when it comes to the Bill of Rights and the Second Amendment. It's not that hard. Again, judges apply historical documents every day to modern-day controversies. Doing it for the Second Amendment is no different than doing it for the First Amendment or any other controversy in the American court system that relies upon some form of a document, whether that document be an older letter, an older contract, an old statute, or the Constitution. And remember, we've had over 200 years of history associated with the United States Constitution. How many historians and history books have been written for over 200 plus years going back to the 1700s about the text, the scope, and the meaning of the Constitution, going all the way back to the Federalist Papers and the Anti-Federalist Papers and so on and so on. So the idea that somehow today we need more historical analysis to teach judges about the meaning of the Second Amendment, I think that's probably not true. I think it's up to the judges now to do their job, follow the instructions of the text of the Second Amendment, follow the instructions on NYSPRA versus Bruen, and decide these cases. But remember, when it comes to bans on so-called large capacity magazines, all of this is really a moot point because the Supreme Court has already taught lower courts, such as the judge in the District of Washington, how to apply how to apply the legal standard for determining whether or not a ban on an arm, which includes magazines and rifles and so on, how to deal with a ban on arms, including magazines, how to interpret and how to deal with it. And the answer is, to the extent that it's apparent that these arms are commonly used by Americans for lawful purposes, it's game over. There's no need to discuss historical analogs because the United States Supreme Court has already done the work by assessing the historical analogs in the Heller case, by looking at any historical analogs for gun ban cases in McDonald, for dealing with any historical analogs for gun ban cases or arms ban cases in Caetano, which, as you recall, was not a gun ban case. That was a stun gun case, which is not even a firearm, but again, it's a form of arm. So at the end of the day, this discussion of historical analogs in the ban of the magazine ban case in the District of Washington is actually a waste of time, in my opinion, because the legal standard has already been set forth by the Supreme Court, which these lower courts are obligated to follow as inferior courts under Article 3 of the U.S. Constitution. Okay, I hope you learned a bit something here at the Four Boxes Diner. If you have not subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.